Hi. In this session, we'll talk about intellectual property, specifically copyright and the law. Now, the internet does not change existing law. For example, if somebody steals something from your garage or from your bank account online, it's still theft, child pornography, or threats, libel, intellectual property infringement. It doesn't matter if it happens in the real world in your backyard or at school or over the internet. It's still illegal. That said, the internet can make some crimes easier. Now, criminologists have identified 3 elements that are necessary for a crime to take place. The first is motive. Someone has a reason to commit the crime. The second is means. They have the method to commit the crime, the gun in the cartoon up here. And third, they have the opportunity to commit the crime. There's a bank in the neighborhood, let's say. So it's this area in here that is the sweet spot where when those elements converge, a crime takes place. Now, the internet has the effect of making the means more accessible for some crimes. Not all, of course, because you can't shoot someone over the internet or knife them. But it dramatically increases the opportunity. For example, crimes can be committed at a distance where the perpetrator is not in the same legal jurisdiction as the victim. So you complain to the police, but they don't know what to do because they don't know where the person is. A skilled internet user can be anonymous, so you don't know who committed the crime. It's certainly convenient because it's as close as your nearest computer or cell phone. With the digitization of all media, crimes such as copyright infringement become easy. And with automation, it's as easy to duplicate one illegal copy of a song as it is to duplicate 1,000, or to send one illegal spam message compared to sending 1,000,000. Well, if the internet has made crime easier, have we seen an increase in crime? Internet crimes are reported to the Federal Internet Crime Commission, the IC3. And here we see the total number of internet crimes reported to the Commission from 2010 to 2014. So we see that crime has stayed relatively even, or maybe a little bit lessened as we've gotten to 2014 or 15. What kinds of crime are committed on the web? Well, in 2012, the top 10 internet crimes were these. The most common was identity theft, with 18% of the internet crimes being to steal someone's identity. Now, what's this other? Twice as many as identity theft. Well, this huge red section is everything else. That's where, hidden in there, are the crimes against children and the intellectual property crimes. So let's take a look at how we can quantify them. So K-12 internet crimes in the second half of 2014 would be threats against children. Now let's take a look at this. These are the 35 categories of internet crimes that are tracked by the IC3. And by this time in 2014, at the end of 2014, ranked number 1 was for non-payment or non-delivery of requested services. So you buy or sell something on eBay, but you never get paid for it, or it never arrives. Now, the threats against children, if we would name them for the adult world, would be harassment and threats and violence. And those are 14th and 18th most popular internet crimes, most common. Our threats against children are down to 23 out of 35 categories, and fewer than 1,000 threats have been reported federally. So it's interesting to keep this in perspective. Intellectual property rights crimes are 24th. So they're less common than the threats against children. Again, under 1,000. Each of them are about 0.5% of the reported internet crimes. So we've been talking about intellectual property, but what is it? Well, it's an idea or knowledge of how to do something. So somebody can steal my dinner, but they can't easily steal my knowledge of how to make that. There are 4 kinds of intellectual property that are protected by U.S. law. One that you hear of the most and of most interest to companies is the patent. It lasts for 20 years, and it's for a manufactured product. A drug company invents a new drug. For 20 years, they have a monopoly on that drug. Copyright is actually the right to copy something. And it's actually for the expression of an idea. And the copyright on, let's say, a book or a movie or a photograph. And the other 2 are trademarks. For example, the Coca-Cola trademark may not be used by anyone else, only Coca-Cola. If someone else uses it, the force of law applies. This little R at the end means it's a registered trademark. And finally, there are trade secrets, which are temporary business knowledge that if someone steals it, that is a violation of law. Well, how about copyright? Specifically, what is it? It's a law. It protects the exclusive rights. It gives someone a monopoly. That monopoly goes to the copyright holder. That used to be the artist or inventor. Now often it's a company. For example, the company that has made a movie. And it gives them a monopoly over the use of a work. Now, a work is a fixed creative expression of an idea. Ideas can't be copyrighted, but a fixed expression, a photograph, a book, a poem, a song, a movie. All of those are fixed creative expressions. Now, you've seen the copyright symbol. That implies that all rights are reserved by the copyright holder. Exactly what rights does a copyright holder have? Well, the right to reproduce the work, in other words, the copyright, to prepare derivative works, the right to publish the work, which is to make copies, to charge money for it, to advertise, to distribute and sell it, to publicly perform or display the work. And there's a similar idea for the public display of work. Well, where does all this come from? The legal justification for all intellectual property is the U.S. Constitution, specifically one clause. Section 8 of the Constitution gives the powers of Congress. The Congress shall have the power, and then each clause delineates that. Clause 8 is to promote the progress of science and useful arts. So Congress has the power to do this. That's the purpose of copyright and patent. It is the sole legal purpose. There is no other legal purpose other than to promote progress for the common good. Now, the means by which that is accomplished is to give authors and inventors a monopoly, the exclusive rights to their work for a limited time. So again, The purpose is solely to promote progress for the common good. The means for that is to give authors and inventors, copyright holders, a monopoly for a limited time to keep them producing as an incentive to them to contribute to the common good. So, Stephen Foster was probably the most popular composer in the 1800s America. His songs were sung and played everywhere. He was so popular, his music was accepted across the country, but he died penniless. How can that happen? Well, at that time, copyright did not protect music. So his sheet music was copied and printed by printers and publishers who gave him no credit and gave him no royalties. So copyright has been a power for authors to use over publishers who would rip them off, who would steal from them and not pay them back. And it was for the benefit of the public so that Stephen would continue to thrive and wouldn't die early. However, things have changed, partly because of the internet, partly through the growth of large companies. So now, a major film isn't produced by a Stephen Foster, it's produced by a company. The copyright is held by a company. So it's now a power wielded over publishers, and who might take that movie that they make. Well, somebody in the public might download a copy of it over the internet for free. So now copyright has become a power wielded by publishers over the public, ostensibly to protect authors, but really the role of the author has changed. And who benefits from this? Well, most of the benefit is for the publisher, to the publisher at this point, to the company. And a little example of that is the old FBI warning that you saw on videotapes and DVDs. The FBI didn't put it there. The publisher put it there. And it was put there to basically frighten you into not copying this. Would copying it be an infringement of federal law? Well, yeah, sure. But not a single person has ever been prosecuted for making a personal copy of any DVD or tape of any kind. So this is kind of a parody on sharing and what has happened. So kids are taught that it's good to share, and it used to be common to loan someone a good book that you read, or to let them listen to a CD or a tape that you had bought. But now, with a digital book or file or video, you're not supposed to do that. So a teen not quite knowing that or respecting that, according to the cartoon, would run afoul of the law. In practice, has anyone ever been jailed for that as a teen, just for downloading music? No. The music companies have filed charges for 20,000 to 30,000 individual users for downloading a dozen illegal songs. Only one of those ever went to court. All the others were settled out of court. So it becomes an interesting discussion of how the law changes for high school students, and it's something teachers need to know a bit about. What's the artist's perspective on this? Well, it's Pablo Picasso is sort of the quintessential painter, and one of his famous quotations is that good artists copy, great artists steal, recognizing that in art and science in all fields, ideas build upon ideas that came before. And a kind of a corollary of that is if you lock up ideas for 20 years or 140 years, you may run the threat of limiting the progress that our original drafters of the Constitution wanted to preserve for all Americans. So, can you use copyrighted materials legally? Well, there are half a dozen ways of doing that. So, when you purchase a book or a CD, you have purchased the right to use that personally. If you want to put somebody's image in a book or use it in a program or play their song at an auditorium program, you can get written permission from the copyright holder. Fair use is something that is especially appropriate for educators. So most educational uses of copyrighted material can be done without breaking the law under the category of fair use. If you don't know about Creative Commons, you need to know about that. This is one of the little symbols of Creative Commons, CC for Creative Commons instead of just the single C in the circle for copyright. And in this case, this says that you're allowed to use something under a Creative Commons license. This image, by the way, by Michael Molenda, he released that as a Creative Commons licensed image, meaning I can use this however I want to, as long as I give him credit and I don't charge for it, and I'm a nonprofit. Further, schools teach Shakespeare and works like The Great Gatsby, but those are out of copyright. Shakespeare was never in copyright. They are in what's called the public domain, where copyright can't touch them. So to teach those works, students could legally download a copy of them because they are no longer copy protected. And then for photographs or artwork or whatever, anything you can make yourself you're allowed to use in any way that you want. So this is a little overview of copyright law and some of its ramifications.